Good morning. Welcome to the Court of Appeals. We're here this morning on the matter of in re adoption of D.R., a matter that was continued from earlier in the month, and we appreciate councils being here today to favor us with their arguments. As you may know, we don't schedule oral argument in every case. Just as a matter of routine, we schedule argument only when we think it will be of some assistance to the court. And that's why we scheduled the argument here, and we look forward to your answering our questions, otherwise making your position known to us. We allow 15 minutes aside for argument. You are saving 5 minutes for rebuttal?
Yes.
Very good. And you'll have 15 when it's your turn in the middle. We ask counsel each time they come to the podium to state their appearance for the record. We live stream the arguments and occasionally need to go back and listen to some part of it. It's very helpful to be reminded of who is saying what when. I don't know that what when even is proper English, but who is saying what at any particular point in time is just so needlessly wordy. Have I neglected anything else that should be mentioned? Very well, then we'll hear from appellant whenever you're ready.
Good morning. Alexander Marshall and Jason Richards for the appellant mother. As a preliminary matter, to the extent that this court finds the noncompliance, the response brief's noncompliance with Rule 24 to be inadequate briefing, we believe we've met our burden to show a plausible basis for reversal under Broderick. This is an adversarial process, and these are private parties, not institutional ones. That process has not been rigorously pursued here. This court should decline to fill in the gaps for the appellees. Regardless, we do not rest on the lesser burden of Broderick because what happened in this case is reversible error.
Can I ask you a question about that?
Sure.
As I understand the Broderick standard, it more typically applies when the party hasn't responded at all to an argument. The briefing failures here were, there was no background section, there was no statement of the issues, but he did at least respond to the arguments. So why would we be in Broderick territory?
It's more that there wasn't adequate analysis and there was very little citation to authority in some of the sections. It doesn't apply to every section, and that's why, again, we're not resting on that. But to the extent this court finds places where that analysis is not fully developed in the responsive briefs, we just ask that the court have that burden in mind. Utah Code, case law, and constitutional law dictate that there are only two circumstances under which a non-parent may legally obtain custody of a child. The first is consent of the parent. The second is unfitness of the parent. Here, the relatives wrongfully gained custody of a child without showing either, and then the district court wrongfully relied on the bond between the child and the relatives to award them custody over mother, a bond that never would have existed but for the wrongful custody order in the first place.
She rescinded it, but didn't the mother here agree to allow the relatives to take child to Idaho so long as certain conditions were met? She had second thoughts about that, but the initial removal to Idaho was with her permission.
It was. There was a short period of time where she agreed, and then she did rescind that both verbally and in writing and told pretty much everybody who would listen that she was rescinding that. And in fact, that almost makes the errors here worse because under VKS, it's very clear that a consent-based order, so if mother was revoking consent, there is no place for any kind of best interest analysis or even question as to whether mother can revoke that guardianship. So to the extent mother consented, that makes the problems here worse, not better.
Let me ask you about the statement you made just before the question about the bond essentially being faulted, I guess I would say, at the guardianship court, right? That mother was precluded from having that bond because of the action of the court. But in this recent decision out of our Supreme Court in re A.H., at least as I read it, that's not something that is considered, right? You just consider the point in time where you are, how you got there, doesn't so much matter to the best interest analysis. So is your argument that we shouldn't be in best interest territory?
Yes, partially. So, and admittedly, this gets a little bit wonky because we have these two proceedings that happened. And we're not in the same universe of facts as we are with the A.H. case. There, the Supreme Court was saying that this court can't And the juvenile court can't go back in time and blame wrongful decisions, like by bad actors, like DCFS not doing their job and facilitating sibling visits and that deteriorating the bond. That's a little bit different than what we're saying here. Here we're saying the very legal basis for the custody in the first place was illegal. So it's not a situation where, they just didn't facilitate enough visits and that was the problem. If that was our complaint, if we were just saying, yes, relatives gained custody legally, but then they just didn't facilitate visits, they cut visits off, that would be a different argument. Here we're saying this should never have existed because the initial orders were wrongful.
I'm not sure I'm understanding the distinction though, because as I read in Ray AH, the challenge to the conduct by DCFS was that they had failed to live up to their statutory obligations. And you use the term illegal, but it seems to me if you're violating a statute, that could be categorized as illegal or claimed as such. So I'm not sure I see the distinction here, because what I understand your argument to be is that the guardianship court never should have awarded the guardianship to the Idaho relatives. And because of that action by the guardianship court, that is what deteriorated the bond between mother and child.
Yeah, the district court never should have gotten to the best interest analysis. I mean, that's the long and the short of it, is it never should have gotten there because she should have been able to revoke that guardianship at day one. I mean, she should have been able to revoke
So
it.
let me ask you this. There's a reference in the district court's order that there's no case early in the order. Maybe it's easier if we just turn to it. So this is, well, it's attached to your brief, but it doesn't have a record site on it. So it's tab A, and it's the district court's conclusions of law and order, and it's the end of paragraph 4, which is on page 22. And the district court said that without being directed to relevant legal authority, the court is not persuaded that mother, who was still unable to care for the child because she was incarcerated, was entitled to terminate the guardianship so that a different guardian could be appointed. And I guess the question is, if mother was capable and able to have custody, then she could have terminated the guardianship on her own, in her own interest, and taken custody of the child because she was capable. But here we have a situation where mother wasn't capable, and so she's trying to essentially revoke one guardianship in favor of another. And as I understood the district court looking at that, there wasn't any case law that the district court at least saw that permitted mother to be the decider of who the proper guardian is. And so I guess my question to you is, does that case law exist, or is that the wrong question that we should be looking at?
It's not the wrong question. There's just a little shift in framing. So it's not a case law decision, it's a probate code decision. The probate code does not allow for a court to intervene on this level for a probate guardianship. So mother could revoke the probate guardianship regardless of whether the court thought that she was unable to care for the child. She made alternate arrangements. Those arrangements were not found to be problematic or an issue in any way. She appropriately designated a guardian. Her parental presumption is fully in place.
Well, I think there was at least a logistical problem with that guardianship, in that that guardian wasn't able to care for the child during the daytime because she worked, and there wasn't a child care spot available. So child was in custody of back with the grandmother and the older sibling.
Again, there's no place for that analysis in the probate code. A probate guardianship is extremely limited. It is only consent-based, or only if the parent is literally absent or completely unfit at the time of the probate guardianship. So,
Well, and you're not disputing that mother was unfit, right?
we do. We do also dispute that.
Even though
That's
she was
separate.
in prison?
In prison doesn't make you unfit, unless it's over a year. So under statute, just the fact that she's incarcerated doesn't mean she's an unfit parent. It does mean that she is like unavailable, but as long as she makes alternate arrangements, that's her prerogative to do. Otherwise, we would just be terminating everybody's rights as soon as they go to prison. So that can't be right. And the court actually made these findings, I think it's earlier in her order, rejecting that as a basis for unfitness, her incarceration as a basis for unfitness, because it wasn't over a year. It's only a few months.
Right, I do recall that now that you mention it. So the question then is, for me, in your argument, in the probate code, the guardianship was either a consent guardianship or none at all. Are those the two options we had?
So
The
there's
relatives
three-
couldn't step in and petition for guardianship outside that?
There's three bases in the probate code that are provided under 75-5204. The court may appoint a guardian for a minor if consent is the first one, A. Parental rights have been terminated, not at issue here. And C, the parent is unwilling or unable to exercise parental rights for any reason, including suspending parental rights. That's what presumably the relatives are resting on in terms of the propriety of the initial guardianship. And the problem with that is that phrasing, in order to be consistent with the rest of the code, has to essentially amount to unfitness. It can't be anything less, because you have other statutes, like the one that we cited in our reply brief, 84205, which is, I'm sorry, no, not that one, 84303, which is under the termination, or in the custody to a non-parent. It's a specific code that gives that custody, and under that, it has a very, long list of requirements that have to be met, including a finding of unfitness. So it'd be inconsistent if the probate code can grant a guardianship for something lesser when other parts of the statute do not allow that to happen. So we can't read that phrasing as anything less than a finding of a pre-existing finding of unfitness. The probate code is not, or the probate court is not empowered to make that finding of unfitness. That has to be done already. So that's what we're talking about. Or we're talking about full incapacitation, like they're in a mental
So who makes the
institution or
finding
they're
of
dead.
unfitness then, under
The juvenile
that?
court. That has to be made by the juvenile court. So it has to be filed as a petition in the juvenile court to either terminate that parent's rights or through an adoption petition that is done prior. But there has to be a
Which we
pre-existing
got to
finding.
in this case.
We eventually got to it, but not at the time of the probate code guardianship.
But,
Things were essentially out of order.
right, there is this rather narrow aspect, I think, potentially for upholding the probate court decision to appoint the Idaho relatives as guardians. Namely, when the matter came on for hearing, there were no objections. Godmother was present, but didn't testify or object, later claiming that was due to some technical difficulties. And mother, who had had ample notice of the proceeding, wasn't available because she was incarcerated at the time. So, no objection stated. It doesn't seem completely outside the realm of normalcy for the petition to be granted.
This is where the legal errors run headlong into the due process problems, and we outline those at length. While they had constructive notice, mother and the godmother had constructive notice of what was going on, mother was not provided with a copy of the guardianship petition. She didn't even know what part she was objecting to. Nonetheless, she still filed an objection the same day that it was entered. She tried to make arrangements to attend the hearing. That wasn't made available to her. And the probate court didn't really seem to care either way, that she wasn't there. And they knew she was incarcerated. So it's not like the probate court just thought she didn't show up. They knew where she was. She was incarcerated. Godmother, her testimony on record 445 and 40 through 47 is a little bit different than what the district court's findings were, because she says, I was on the phone. I was trying to object. They couldn't hear me. The judge never asked for my opinion, despite knowing I was in the hearing. And then she was immediately emailing the clerk, but got no response. And then mother files her written objection the same day. I mean, she objected the best she could under the circumstances she had. So in those circumstances, it was, even if the probate court was not completely out of line for initially granting the guardianship because it thought there were no objections, the second it received that letter that is her stating written objections, that should have terminated the guardianship right then and there. No questions asked.
Okay. I'm sure you're going to tell me this is a terrible oversimplification. But I find myself thinking about the possibility of, okay, this did not all happen as it should have. There are problems along the way with that probate guardianship. That matter later got consolidated before Judge Scott with the matter at hand. That's all water under the bridge now. Unfortunate though it may have been, the order before the court now on appeal is, and often you're here complaining that adoption shouldn't have gone through, we should have considered lesser alternatives like a permanent guardianship. And indeed what we ended up with here was a permanent guardianship. Parental rights weren't terminated. Adoption didn't occur over her objection. Why should not we I know this makes it sound more trite than you would be happy with, but why don't we just let bygones be bygones as concern the probate court and focus our jurisprudential energies on analyzing whether or not the decision here ultimately to not terminate parental rights, but rather to impose the permanent guardianship while mother retains her residual parental rights. Why shouldn't we just be looking at that?
Yeah, so I think that's actually the core of this case. I think you hit right on it. And this sort of goes to your question about how we really view the district court's ruling in light of the earlier mistakes, even if we agree that those are mistakes, how does that really affect the decision? And I think there's two ways that this court can do that. And they're interrelated, but I think they're distinct pathways. The first one is through sort of a structural error lens, which we talk about in our reply brief. The errors that happen at the probate court stage and then the failure to dismiss that guardianship created a sort of structural error that where we can't even begin to speculate as to how these proceedings would have gone had that mistake not happened. And this is a legal error that the order should have never happened. It's not that, someone didn't do something right. It is the court erred. So it's a different category of error than what we were talking about in A.
I struggled with that a little bit, though, in the reply brief, and here's why. The whole notion of structural error, in part, is based on the idea that there are some errors for which we can't tease out the prejudice. You just can't. You can't sort of unscramble the egg and figure out what would have happened differently. And I think this sort of has shades of Judge Orm's question. Here we've got Judge Scott looking at the whole situation, and Judge Scott does enter findings that because of mother's ongoing drug problems, that mother's not been able to provide the care that she would have been able to provide if she did not have these drug problems. We've got a whole bunch of findings from Judge Scott about the fitness of the relatives in Idaho. And so I'm not totally sure why this would be structural error if we've got Judge Scott looking at the very things you're telling us that she couldn't. We can't figure out what would have happened if she would have looked at them, where she is looking at them.
Because so many of her findings, so much of that decision rests on the state of not only the bond between child and mother, that it was deteriorated, but also the bond between the relatives and the child, which never would have existed at all had this wrongful order not been entered in the first place. We can't tease that out from her overall decision. It's so central to so many of the findings that she makes. Yes, we have unfitness findings, and even if this court disagrees with our challenge to those unfitness findings, we still can't say whether the court would have changed her mind based on that, taking out those bond findings.
I take your point. She does make a lot of findings about the bonding, but she also makes a lot of findings about mother's ongoing drug problems. And she also makes a lot of findings, really specific findings, I thought, about the Idaho relatives' fitness and the love and care. And I guess your point is they never would have been in a position to bond with her. But that feels at least a little bit separate from the findings about their fitness, right? I mean, you sort of have a set
about the relatives' fitness?
Yeah, the relatives' fitness. You've got a set of findings about the bond, but you've also got a set of findings about, like, there's a stay-at-home mother in the home. They've provided diapers, they've provided necessities of life and so forth. Those all seem a little bit independent of the bond problem, I think.
They are, to an extent. I think maybe what you're getting at is if we go with the unfitness finding, if we find that was sound, then we're sort of backing out of parental presumption. And
yeah, that's a fair part of it, yeah.
And then we're looking at, who's the best placement. It's more that kind of a question. The problem with that is, and I didn't even get to the second thing, but the problem with that is we just can't know. We can't know that that's what the district court would have done had that bond not been so central to her decision. And then on top of that, the second thing is we have the due process errors. We cannot infringe on a parent's rights, regardless of whether it's terminated or not. We cannot infringe on a parent's rights without due process, and that just wasn't given here. At the end, we got there. But again, because that beginning part of the proceeding was so lacking in due process, I mean, had the phone worked and Ms. Mendoza had been able to say, I object, she made me the guardian, I want to take care of this child, which is what she testified to, that guardianship never would have been ended.
Except on that point, we have a finding from the district court that Ms. Mendoza had been instructed by mother to not say anything. So what do we do with that?
Looking at the testimony in 445-47, I think that's really helpful in informing what happened. She's asked she was asked, Ms. Mendoza was asked why she didn't file an appeal, and she said because Mother was going to do that. And Mother did. Mother filed that letter objecting to the guardianship the same day. So in the sense that Mother maybe instructed Ms. Mendoza not to do anything, it's because she did it. So it wasn't that they were trying to backtrack or not object. They absolutely, I mean, the record is replete with her trying to object at every turn. She's trying to object. And the court is just plain ignoring her. And then gets to the point where when she finally files a motion, the court says, well, I'm going to wait and see what happens with the adoption petition. Again, the probate court had no basis or authority to do that. As soon as she requested that that guardianship be dissolved, it needed to be by law. So we ask this court to reverse, unless there's further questions, we ask this court to reverse the district court's permanent custody and guardianship. order.
Before you sit down, I do have questions about the ICPC issue,
Oh, yes.
which we did not get to, but we shall. I'm wondering if we could talk about the prejudice component of what to do with the ICPC violation, assuming there is one. First question, and it's more of a record, and it might even be just an extra record question, but I'm going to ask it anyway. Has Idaho since done anything like this? Are you aware of Idaho ever looking at this?
No.
Okay. Suppose we agree with you that that's problematic under the ICPC. Is it, what happens if you have non-compliance with that particular provision of the ICPC? And to put the card more directly on the table, can there be retroactive compliance with that provision?
Under In Re BH, which is a Supreme Court decision from a little while back, yes, there can be essentially retroactive compliance, but it still vacates the order. That's what happened. So that was an adoption case where the ICPC was not complied with. The court agreed that that was a pretty big problem and vacated the adoption decree to go back and comply with the ICPC. I would make a little bit of a distinction here, although if that's the only error this court finds, that's probably the right answer.
Right, and let me just pause, not to derail your answer, but it just feels like if we were to say that it was deficient performance to not raise it, and or obvious error for the courts who have not sort of seen the problem, why wouldn't, in response to the ICPC problem, which puts aside all the due process stuff, why wouldn't we just simply remand it to the district court and give the district court some period to allow the Idaho authorities to take a look at this? Why isn't that the best outcome?
Because it just overlooks the prejudice problem with the noncompliance in the first place. So the whole point of the ICPC is to prevent a child from being sent out of state before we fully vetted what's going on with that placement.
I'm not sure that's the whole point, though. I mean, Article 1, Section 1 of the ICPC says, each child requiring placement shall receive the maximum opportunity to be placed in a suitable environment. And your point is that the way we figure out if they're being placed in a suitable environment is by doing this review. But if there's no indication that the Idaho relatives are not fit, if that's what the end point of all this process is going to be, then why isn't it in the best interest of the children systemically to just sort of go back and say to Idaho, okay, you've got 90 days, look at this. And if Idaho comes back and says, you know what, they're not fit, now we've got the answer. But if they come back and say they are fit, now we have the answer. Why isn't that the optimal solution to this problem?
Because there's a reason the ICPC does not allow children to go until that process is done. And that's because we don't want to ping pong children back and forth. I mean, this is an extreme example, but taking these sorts of principles to their logical extreme, someone could literally kidnap a child, go across state lines, develop a bond with that child, and then file for guardianship and say, well, I'm bonded with that child. Oh, well, I mean, this is sort of the problem
Except
from
engaging with
AH.
engaging with your problem there, it's hard to imagine that if somebody literally kidnapped the child, that the Idaho authorities would say, you know what, this is the best placement, right?
Eventually, but then that bond still exists, that prejudice has still happened. I mean, legally, it'd be much harder to defend that position, but what we're saying by allowing non-compliance on the front end, lack of due process, all of these problems where we're entering what amounts to an illegal order, and allowing that to stand long enough for the prejudice to take hold, is we're condoning that. That's what happens. That's the legal result of not enforcing these kinds of regulations up front and saying, well, then we can just retroactively comply and it's fine. Because in this case, yes, it's fortunate that relatives are a suitable placement. But what if they weren't?
Is there any indication?
That comes to my related concern. I come at it from a slightly different perspective. I'm riding the familiar horse of water under the bridge, and let us move on with what really matters here. Yeah, the ICPC should have been done back when, because at that point in time, the Utah court knows nothing about this family. And so to have the home and the parents and all vetted by local authorities, what a great idea. Fast forward a few months, now Judge Scott is right on top of things and knows about these parents and the dispatch with which they got the child to a pediatrician, the diaper rash reversed, car seat bought, fitting clothes taken care of, knows lots about the home and the family and the siblings. At this point, it seems kind of counterproductive to say, oh, well, Idaho, why don't you check them out? Judge Scott at this point has checked them out. So we've gotten, things have moved along at such a point that it seems to me that while an ICPC should have been done way back when, the reason for getting it done is water under the bridge at this point. We know lots about this family now and the suitability of their home and themselves and this as a placement for the children.
I'm gonna take
So
some.
where's the harm?
I'm going to take some factual issue with some of that.
Okay.
Because although Judge Scott knows what was presented in her courtroom, she doesn't have a compliant background check on this family. And again, this is not to say that it's going to turn up anything awful, but I have to argue as if this were any case and any people. So what is required under ICPC is a national level background check because like what they supplied was a Utah background check. Well, they live in Idaho. Nothing's going to come up in Utah. They might as well pick Alaska. It doesn't really matter. They have to provide a national level background check, and then there's home visits and there's studies and there's things that actually happen in Idaho in their home, kind of consistent with what we would see as a custody evaluation in a divorce case. So we're essentially saying that, okay, well, they came into Judge Scott's courtroom and she listened to them and they presented evidence, and mom's evidence was much more geared towards maintaining her own custody. It wasn't there to slam them as a placement. So it's a little unfair factually to say that they're fully vetted because under law, they're not. Whether they would pass that vetting, different question. But at this point, they are not. They never provided any of that information. So factually, I think it's a little hard to say that it's water under the bridge, no harm done. We can just proceed as we have been. And really the water under the bridge argument, conceptually, the problem with it on a whole level is that would happen in every single one of these cases.
So then maybe I get on board with Judge Tenney's suggestion. Okay, to the extent that there is any concern or the possibility of some problem, let's have the ICPC done now.
Yeah, and like I said, if that's the only error that this court finds, that's the right answer. That there's retroactive compliance with the ICPC, we just check those boxes and we re-enter whatever order. If the order is vacated, though, we do have to do a present tense best interest analysis. So if mom has continued to do well, if she's sober, then it sort of answers a lot of Judge Scott's concerns about, well, I don't really know if mom can stay sober. I don't know if she can stay committed to that, which is the threshold legal error that we point to in her unfitness finding that is consistent almost exactly with what happened in JAL, that the court has to find whether she was able to do that within a reasonable amount of time. So if we go back on a vacated order, even if it's just vacated on the ICPC, we still have to do a best interest analysis that in the present tense, which would bring in sort of evidence that goes straight to that concern and possibly result in something different.
Thank you. You've used twice as much time as you were allotted, which is entirely all our fault and in no part your fault. So you'll have your 5 minutes on rebuttal.
Thank you.
We'll hear from the other side.
Good morning, Your Honors. Theodore Weckel on behalf of Tyler and Katie Colby, who are also present here today. And enjoyed the conversation, and feel free to keep going as far as your questions. I wanted to address a couple of points that were raised in the discussion. As I see it, Code Section 755204, which counsel alluded to and actually talked about, this unable to exercise the parent's parental rights for any reason, very broad statute. I don't think it has to do solely with unfitness as counsel was arguing. The court has broad discretion And could be incarceration, could be temporary illness of a parent, maybe it's a single-parent home. Could be that they're on travel or business status or something like that. Could be they have to go care for a relative or something. Any of those things could apply, and the court would have discretion and statutory authority, I believe, if there's a minor child, to appoint a guardian. So I don't think it's just solely based on unfitness. Secondly, in terms of this
Wouldn't that have due process implications, what you just said? If a court's authority is as broad as you just suggested, the right to be a parent has been recognized by our Supreme Court, this court, and the United States Supreme Court as being a fundamental right.
it is fundamental.
So you just told us that a court has authority to step in and appoint a guardian if a parent goes out of town?
No,
Right?
what I
Did I
was,
hear that
what
right?
I was saying, Your Honor, is that the council had said that unfitness is the sole reason, justification under the statute for the appointment of a guardian. Certainly under a due process analysis, there's notice and a hearing that are required, and there has to be evidence presented before the court could make such a
I mean, that would be the
determination.
procedural due process component of it, but there'd be a substantive due process. I mean, surely a court cannot take away your parental rights, even on a temporary basis, based on something as trivial as the parent going out of town.
Well, if you had a 5-year-old and, there's nobody around to take care of the child, and, the parent had to leave for some reason, I mean, it could be any number of things. Maybe it's a very
Thinking they'd
important.
be back in 2 hours and it ends up being 2 weeks.
2 hours, no. But I think if
No,
it.
but I mean, their intention, okay, you're 5, watch the cartoons, here's a snack, mommy will be back in 2 hours, mommy drives to Idaho, mommy gets arrested,
Yeah.
and is not then available for 2 weeks.
knows
And the
how long.
5-year-old runs out of interesting cartoons and snacks, something's gotta happen.
Exactly. I mean, that's how I look at it, Your Honor. There could be many, the way the legislature wrote that is, the court has to have broad discretion, given any type of fact pattern that it's presented. And certainly, I agree with you that the fundamental liberty interest of a parent is absolute and powerful. But the court also has to balance that with the safety of children. And it has to decide, what are we gonna do when there's a parent who's unavailable? And what, are we gonna just let them sit there and watch cartoons and not have any food until the parent comes back?
What do
So
we,
what-
go.
What do we make of the objection that was filed in the probate case by mother? It's sent in as a letter, it's lodged in the file, it's in the docket, but the court never acts on it, right?
Yeah.
There's, at least as I understand it from the proceeding, there's never a formal consideration made of her objection. So what do we do with that?
Maybe I'm wrong, but I thought that the court, Judge Scott tried to consolidate, as Judge Orme was talking about earlier, where the court was familiar with the objection, and just said, well, the evidence associated with, that we need to determine a guardianship and this
Well,
attempt by
correct me
the.
if I'm wrong, but what I understood Judge Scott to have done with that was to have said that there was no reason to overturn Judge Faust's decision on the guardianship petition, but I don't recall her specifically entering her own guardianship order. Do I have that wrong?
Own guardianship orders?
Right, she addresses the question of whether Judge Faust committed some error, and she says she finds no basis for that.
Yeah, well, as I
But she
said.
doesn't redo the proceeding.
Yeah, as I said in my brief, is that at the time, as I recall, mother was incarcerated. And so I think there is there is case law which indicates that any kind of safeguards for procedural due process, I don't believe are, and I cited to a case, protect the parent in that context. I mean, the court, they're not entitled to perhaps notice and to actually physically be there in court. Is that what you're referring
Well,
to?
what-
No, I think what I'd like to follow up on is, as I understand Judge Scott's ruling, is that she wasn't looking at the temporary guardianship of the probate court, right?
Yeah.
That was a temporary guardianship. It wasn't permanent.
Yeah.
Was my understanding, right?
Right.
And then essentially the whole thing gets converted to a proceeding to determine adoption and whether adoption is the appropriate path here, or whether something less than adoption,
Right.
which would be a permanent guardianship, or Judge Scott could have considered no guardianship at all, right?
True,
She
true.
certainly had multiple options. So I think as I read the record, she was taking what had been perhaps an objection to a temporary guardianship and folding it into the mother's position in objecting to the adoption proceedings.
Yeah, that's,
Whether that's procedurally appropriate or not, I think that's at least how I understand
Well,
how she
and
proceeded.
there could be a timing issue on this, but once the relatives filed the petition for guardianship, or for adoption, actually, then of course, there's a live case in front of the court. And so, I would think that the court has broad discretion, how to handle, an objection from the mother. Now we've got a petition for, adoption,
And
filed.
Mother was appointed counsel for that proceeding in front of Judge Scott, right? I mean, there's no question that she had all the due process she was entitled to in that proceeding.
It
At least
could-
I don't see them making the argument that she didn't have that due process provided to her in the proceeding in front of Judge Scott. So
Yeah.
I guess the question is, as appellant has framed it to us, the errors all occur in the case before it gets, or well, not all the errors they're alleging, but perhaps the largest errors, we'll say, occur in the probate court before the case gets to Judge Scott.
Yeah, that's what she said. I think, again, the court has very broad powers to do what's in the best interest of the children, of the child in this case. And so it's got to balance all of these different factors. And timing could be an issue here. This did appear before Judge Faust. He did rule on the objection, I believe. He did rule on it and denied it, as I recall. I could be wrong. But I think the issue is.
I believe they're telling us that he did not rule on that.
He didn't rule on it?
That's my understanding of the blue
All
side
right.
position.
Let me look at my notes, Your Honors. I may have some comment on that.
And I didn't mean to cut you off, Judge Orm, if you
No,
want to jump in.
you actually largely beat me to the punch. I think we're unanimous on this point.
Yeah.
The objection came in after the hearing before Judge Faust. It was docketed in the probate file. Judge Faust never did anything with it.
Okay.
Fast forward again to the matter now before us. Judge Scott did consider it,
Yeah.
did note
Yes,
that it
he
was
did.
in the file,
Yeah.
and said that,
Right.
ends up being neither here nor there in the
Exactly.
context of where we now are.
That's right.
And I need to be looking
Right.
at what's best for the children.
That's right. And
One of the things, though, that we're hearing from the other side, and this is sort of piggybacking off of Judge Orm's question, and this is something that Ms. Marichal was just telling us, and she told us this in her brief as well, is that a large portion of Judge Scott's ultimate decision to award the permanent guardianship hinges on the bonding that had already happened in the interim period between the Idaho relatives and the child. And if they're correct that that bonding only happens because of a temporary guardianship that was infected with error, then how do you unscramble that egg, to go back to the question that I asked her earlier? How do you tease out the bonding that apparently shouldn't have happened? And so why isn't that grounds to just reverse this whole thing and start over?
bonding is something that happens over time. And particularly with a little kid who's like just an infant, okay? And so we don't have somebody who's like an older, teenager or something like that who's got a bond. This is a time of life of a child where bonding is very important.
But that begs the question, if it's true, and I know you're pushing back on the sort of foundational premise of my question, but just go with me on the hypo for a minute.
Yeah.
Let's suppose that they're correct, that the temporary guardianship was infected with error, and let's suppose that temporary guardianship is what then leads to this period of bonding. How do we deal with that for prejudice purposes?
I don't agree with that factually, Your Honor, because as the findings that I read suggested that the Judge Scott specifically said mother was incarcerated. This is a very young, as I said, young child. There's no scientific evidence presented by a psychologist or anything like that in the trial. Mother had the obligation to present evidence associated with this. And we had the lay testimony of various witnesses about bonding. And the court found that mother's bond, which originally, the court did find that there was a bond, and it was a strong bond with this child, but that the child didn't even recognize her later on, when, after she came back and she came out of jail. Okay, those are what the facts of the case were. And so then you have a situation where you've got the relatives who have now developed a very strong bond. So to answer your question, I don't think the evidence supports mother's position. And so she had the burden of presenting her case.
They're not making an evidence-based argument there. They're making what Ms. Marichal is expressly referring to as a structural error argument. They're saying that this is the kind of error for which we can't do a prejudice analysis. And you're focused in your answer on the bonding vis-a-vis mother and the child, but their point is that Judge Scott was looking at the bonding vis-a-vis the Idaho relatives, and their point is that bonding shouldn't have happened. The child should have been with godmother the entire time.
No, I understand.
And so if Judge Scott's ruling is based on the bonding with the Idaho relatives that we're being told shouldn't have happened, what are we supposed to do with that? That's
No,
my
I
question.
understand that, but I think that Judge Scott's ruling did address the original bond between mother and child, the effect of the incarceration on that bond, and the subsequent bonding that occurred with the relatives. I think she addressed all of those different points in her findings. And so I think it's just pure argument, but I think it's also speculation on the part of mother, because we don't really, I'm getting back to the evidence, I mean, we had an evidentiary hearing, we listened to witnesses, there was lay testimony as to the bonding. And so I'm not sure how you could even prove that point. I mean, to me, it's just a pure argument that, well, we're gonna presume prejudice because we know that there's bonding, that occurred between mother and the child. How do we know that?
Well, and I asked appellant's counsel about In re AH, but again, as I read In re AH, when you're making a best interest determination, the Supreme Court found in that case that it didn't matter at the end of the day that it was at the fault of DCFS in that particular case about a broken bond with the biological family and a new bond with in that case it was a foster family. But what you had to do was take the child and the status in the moment that you found yourself with.
Mm-hmm.
And it didn't so much matter how you got there.
Yeah.
And in that case, as I was saying, the allegations were that DCFS didn't meet their statutory obligations. Here, the argument's slightly different, claiming it's a structural error. But I assume that your position is that AH would be applicable here, and that we would take the best interest of the child as it exists, regardless of how we got there.
Yeah.
And I guess my question to you is how is it not then a structural error? Because it seems to me that that's the distinction that the appellant's trying to argue with AH, is that there's something so fundamentally wrong with how we got here in this case that it's different from AH.
Yeah, I mean, I see this as kind of an interesting intellectual exercise, but I mean, I think you have to go back to the evidence presented at the hearing. I mean, I do. I mean, they're saying it's structural error. They're saying that, this failure to act procedurally correct is the basis for denying or interrupting the bond that existed between mother and the child. To me, that's an argument. But I mean, what in the record proves that? I mean, there were findings that the court made when they had that evidentiary hearing, albeit all these some procedural problems, et cetera. Mother was there. Mother had a right to be there. She was there at the trial. She could have presented evidence about all this stuff. She didn't do it. She went and testified, as to what she thought was she should be a good mother and she do the best she could. But the court considered a lot of different facts here. And one of the most important facts was that mother had allowed her first three children to be taken over by a guardian. And now we had the fourth one here, and she's a habitual drug addict, and that she's in she's in prison and jail all the time. All of these different factors, okay? And then what's the court gonna do? Say, well, theoretically, we should allow, I mean, there is a basis for, important, and I'm not trying to diminish, Judge Seni, your position in terms of procedural due process and substantive due process. Yes, those are important for parents, and they have a fundamental.
I'm not sure your answer is totally responsive to my question,
Okay,
to be
I'm trying
honest.
to be
Right,
responsive. Yeah.
you keep coming back to the bond problem vis-à-vis mother and child, but the
Okay.
argument that we're hearing from the other side is
Yeah.
about the bond problem vis-à-vis the relatives in Idaho and the child. And your answer keeps shooting past that. What they're telling us, and maybe there's an answer to it, and we'll certainly explore it in our
Okay.
deliberations, but the problem they're telling us is that Judge Scott's ruling is heavily predicated on a bond between the Idaho relatives and the child that should never have existed because it was only created because of a process that was infected with error. That's the problem they're pointing to. So there's no evidence that mother could
know.
or should have pointed to cure that problem, which is the precise thing they're telling us is the problem.
Well, I think that it was a broader analysis than just that. I think that Judge Scott looked at the best interests of this particular child as required. Counsel said it's not required, but it is required. Under 75-5-206, paren 1A, the court may appoint a guardian. Any person who's appointed would be in the best interest of the minor. And so the court had to consider all of those different things, all of the facts, all of the evidence in the case, including that particular point. And what the court concluded was that it's in the best interest of this child, given the habitual drug addiction of the mother and all of these other things, that this kid should go with the relatives, okay, right now, because we can't, they have to balance the safety aspect for the child with the fundamental liberty interests of the parents.
Can I take the ICPC issue, unless we want to stay on this? Your argument, as I understand it, with respect to the ICPC issue, is that the ICPC doesn't apply because the child was placed with relatives. Do I have that right?
Well, I wanted to elaborate on that point, but go ahead.
Well, do I have that right?
Well, it's a little.
Is that your argument there, or is there more to it?
I think it's, well, there's plain error. They're saying that this is plain error.
Right, the argument
we
they've
didn't
made
do this.
to us is that because the child was being placed out of state by the court, that the court needed to first sort of check this ICPC box.
Well,
There needed to be a
I
study
think
of
I've
that.
got two other arguments, in addition to the ones that I had put in my brief, if I may elaborate on these. One of them was procedural due process under the statute 80-2-905, Article 3, paragraph 4.1, paren 4.1. And I think this was alluded to in counsel's brief.
I'm sorry, Article 3, what?
Okay, so this is 80-2-905, Article 3, paragraph paren 4, paren 1.
Article 3 has two subsections,
No, Article 3,
okay?
paragraph 4, and then paren, let me get the statute here. I thought I wrote it down correctly,
I
but,
printed it off this morning, and the version that I'm looking at has two subsections under Article 3.
okay, here it is.
Do I have the wrong?
And it's, paren 4, paren 1, and it says, no sending agency shall send, bring, or cause to be sent or brought into any other parent, state, and any child for placement. And then it uses two terms. Now, this is a formalistic argument, but the legislature chose these terms. Foster care, which we don't have, or as a preliminary to a possible adoption. Now, we had ultimately a guardianship here. It doesn't mention anything about guardianship, okay? So you could say.
What they're referring us to is Article 3, subsection 2F. And 2F says, the child shall not be sent, ... into the receiving state until the receiving state notifies the sending agency in writing to the effect that the proposed placement does not appear to be contrary to the interests of the child. They're telling us that the sending agency would be the court, which tracks Article 2, Section 2, which
Yeah.
refers to a sending agency as a court.
Yeah.
So what they're telling us the problem is that the court, before
Yeah.
it sent the child to Idaho,
Right.
needed to comply with Article 3, 2F. and that was not done. The
No,
response you gave us in the brief was that didn't need to be done because they were relatives. Is that still your position, or are you backing off that
I'm
position?
modifying it somewhat. I'm modifying it. And what I'm saying is that, just the first argument, I've got two more arguments. One is that in terms of, and it is formalistic, but the statute under Article 3 does not mention guardianships. It says foster care or
Well, it says the child should not be sent into the receiving state. Do you agree that when the district court
I
provided
agree.
a guardianship to relatives in Idaho, that it was sending the child?
Yes, absolutely.
Okay, so it says that the child shall not be sent until the receiving state notifies the sending state that it does not appear to be contrary to the interest of the child.
What I'm
So
just-
how is that complied with?
It does not. I mean, it should have under that particular part of the ICPC statute.
Okay, so if it should have been complied with, then the next step that they've asked us to consider is the prejudice component.
Yeah,
And you heard the discussion that I had with Ms. Marichal on that. Walk me through why they're not prejudiced if
Okay.
there was a failure to comply
well,
with that provision.
and I cited to one case in my brief, which was, it's a North Carolina case, in Re J.E. And in that one, and it was a guardianship case, what happened was, and the dissent said, hey, you didn't do the ICPC, but the majority said, in this Court of Appeals, North Carolina, there were findings of fact, kind of going back to what Judge Orme said. Look, we considered all the evidence here. Okay, yeah, we should have done this. But we had all this, in the findings, there was evidence that these grandparents were suitable, and we had to do something with this child. And so,
To the best of your knowledge, when Judge Scott entered her rulings, had anybody gone and done a home study of the Idaho relatives?
no, not to my knowledge. I
Okay,
don't-
so what we're being told is that the ICPC, the thing that is being contemplated here is something akin to a home study. And so if the ICPC is an interstate compact in which it's saying that before we take kids across state lines, there needs to be something akin to a home study, and it wasn't done, why have they not now satisfied the prejudice argument that they're making? Why have they not made that argument successful?
Well, I think this was alluded to also in the previous discussion with counsel, when that was asked for in re D.H. I'm not familiar with that case, but I believe that, now this gets to fixing the problem, that you could do, like you say, and it's a good
Cure it
suggestion.
retroactively.
Yeah, retroactive, you could do that. But the authority that I cited to, that stands for the proposition that you don't have to, if the findings indicate that this placement was suitable, that these parents, given the evidence that was presented before the judge, they saw these witnesses, they had testimony from the witnesses, et cetera. They made the determination, this is a fit parent, this is a good parent, I'm gonna give the child to them because they look good to me. And the question really is, does the court have discretion to do that when there is no ICPC done? I don't know, that might be a case of first impression, I don't know, in Utah. Other courts have considered that in the United States, the one I cited to did. But I also point out that in my procedural argument as well, that foster care and possible adoption are articulated in the ICPC Utah statute, not guardianship. And so, it's very formalistic, but you could say that, well, this is a guardianship. They don't talk about that in this particular statute. So, and there is a
So
distinction.
you're saying when the ICPC says that a child should not be sent into the receiving state, that a guardianship that places the child in permanent custody of people in the receiving state, that doesn't qualify as sent?
Okay, what I'm referring to, Judge, I don't know if.
I just want to make sure I understand the argument. Is that the argument?
My argument is citing to Article 3. I'm sorry, wait a minute. Yeah, Article 3, and it's actually paragraph 1, I'm sorry. Article 3, paragraph 1, right from the get-go. No sending agency shall send, bring, or cause to be sent or brought into any other party, state, any child for placement in foster care or as a preliminary to a possible adoption unless the sending agency shall comply with each and every requirement set forth in this article. And it's a formalistic argument, but guardianship is not mentioned, okay? And there is a distinction between guardianship
So
an
you're
adoption.
saying a guardianship would not qualify as, quote, preliminary to possible adoption?
Well, that's one possible reading of that, is that the legislature didn't put that word in there, so they didn't mean to cover it. I don't know, it's an argument, so. But getting back to a couple of other points, if I may, I know I've run out of time.
Way out of time.
Way out of time, okay.
So,
All right, sorry.
we will hear rebuttal from
All right.
appellant. Thank you.
Thank you. Alexander Marshall for the appellant mother. Couple places to go. The first thing I want to clarify is just a timeline, because I think it's informative of the prejudice discussion that we've been having. So the guardianship, the initial guardianship petition is filed in mid-June. At the same time, the relatives send a letter to the Board of Pardons asking them to keep mother incarcerated. Then in July, mom executes those guardianship papers formally, has everything signed and notarized, and the probate courts at the same time holds that hearing. And then mom immediately objects to that hearing, and I think we're all in agreement, nothing happens with that objection.
What was the date of the hearing?
I think it was July 15th.
So it's actually.
16th?
It's actually before the notary is affixed to the mother's guardianship?
I think they happen at I don't know if we have an exact date for when it was notarized.
Well, it's actually on the notary document itself.
Oh, yeah.
This is Exhibit E to your brief, and I have to say, it's actually a little hard to read. So I was hoping you could read it, because
I'll take a look.
this is some swirly handwriting, so I can see that it's July 2022.
July-
But I can't tell
oh, yeah.
what day. Can you read that any clearer?
I cannot.
Okay.
I mean, she signs it on the 6th, so presumably it's around there, because I think she has to sign it in the presence of the notary, but her date here under the sincerely is the 6th.
I do see that she's dated at 7/6, but the petition isn't filed until the 16th.
Yeah, so she's executing that ahead of time. And the reason why, if we look at how the record developed, the reason why is because she asked for the child to come back to the guardian she appointed, right, the godmother. And initially, that's refused, and then eventually she signs, it's refused because she doesn't have a notarized letter, so she goes and gets a notarized letter.
Right.
Then the child comes back because
On-
there's a notarized letter, and then the guardianship petition is filed.
So I'm looking at Judge Scott's findings, and finding 54 says that once guardians were provided with the notarized letter from mother, they returned the child
Yep.
on June 17th, 2022, which is the day after the petition is filed. I don't know that tells us when
There was a delay in the
When-
return because, and if you look in the transcripts, I think the godmother talks about this at that record 445 to 47. She says there was a little bit of a delay in, like, they agreed to return and then they waited for a weekend for work schedules to do that, so it ended up aligning. But in terms of what was triggering what to happen, the guardianship petition was filed because they knew they were returning the child.
Right, and there is a reference in paragraph 54 that the letter initially wasn't notarized, so I'm not 100% sure that the July 6th date tells us when the notary occurred, because that
It was a
could have been
different
the
letter,
initial,
wasn't it?
the initial date.
There's a couple different letters. It really, it doesn't actually matter which one happened first. What I'm trying to lay out in terms of the timelines is that there's a significant amount of time where this objection, if this was even at the end of July, sometime in July of 2022, the court receives this letter. And I believe it received it the same day that it entered the guardianship. That's in the record. So it had to at least been notarized prior to that. The time between the court receiving this objection and then we get to November, when mom is actually released and she files a formal motion to terminate the guardianship, that whole time is an illegal guardianship under the probate code. So from July to November, we have that problem. And it's also pretty strongly supported in the record that Ms. Mendoza, the guardian chosen by mother, was going to facilitate in-person visits with mom and child. So there's a lot of difference between those few months. Even though mom was incarcerated, she made arrangements to make sure that her bond with child was as impacted as little as possible. And it's easy to say, well, it's an incarcerated parent, you made choices, you got incarcerated, that destroyed your bond. But there's many other scenarios in which a parent is involuntarily unavailable, such as deployment. But we don't want to say, well, because you're deployed, you don't have a bond with your child anymore and a guardian can take over. Like, this sets a dangerous precedent for those kinds of things, even if we don't fully approve of what mother has, like the choices that mother has
One
made.
of the things we heard in response there is that under the code, the court has broad discretion precisely because of the potential variety of factual circumstances. Why is he wrong with that?
Are we talking about the probate code?
Yeah.
The probate code court does not have broad discretion because those guardianships are not intended to be overriding a parent's rights, and that's
Right, it's a temporary guardianship,
So
right? I mean that the guardianship in the probate code was temporary in this case, right? And it's the petition for adoption that gets us into the question of what's the permanency of the situation here? Should this child be adopted? Should it be permanent custody or guardianship? Should it be something different?
I think there's a confusion in nomenclature because we call the latter thing permanent custody and guardianship, but it doesn't make the probate guardianship temporary. There's no end date on the probate guardianship. It stands as long as it stands. So there's nothing in the probate code or in the order itself that indicates that it's temporary in any way. If mother had never raised an objection, that would go on forever. And it confers the same rights as a permanent custody and guardianship. We just put the word permanent in front of permanent custody and guardianship to indicate that the parent can't challenge it.
But in the former scenario, mother can revoke that. If it's a
Correct.
voluntary guardianship, even if open-ended, it's subject to termination upon indication, okay, I'm out of prison, I'll
Right.
take my child back, thank you very
Which
much.
is exactly what mother asked for, and that didn't happen. But it doesn't make it temporary. It doesn't make it any less of a guardianship, is what I'm trying to say, in terms of the legal rights conferred than the
It's just
permanent one.
It's revocable.
It's revocable, that's right. So, and I want to point the court to the comments in 75-5204, because that's the guardianship statute. It says, nothing in this article is intended to deal with the status of a so-called natural guardian, a parent, with the authority of a parent over a child or the authority over a child and children that may be conferred by other state laws. This is not intended to infringe on parental rights. The probate code is not supposed to do that. The probate code is only supposed to enforce the wishes of the parent, or if the parent is somewhat like incapacitated mentally, physically, and has made no arrangements, it allows a guardian to step in. That's it. But we cannot allow the probate code to override the wishes of a parent that has not been found unfit without treading into very dangerous territory. And the last thing I'll just add to respond to the hypothetical of, well, if a 5-year-old's left alone, and runs out of snacks, I think that comment speaks to that, but the solution there isn't to get a guardianship. The solution there is to call DCFS. That is a whole statutory scheme that is built to deal with when we have a child that is not receiving proper parental control. The relatives could have availed themselves of that statutory scheme. They did not. They got a guardianship. That was erroneous, and that's why we think we should reverse.
Thank you very much. We appreciate the arguments. We ran longer than we intended, as is our occasional practice. We have a couple other matters of business. We'll take a very brief recess to reconfigure the panel, and we shall return without Judge Tenney.